The men's and women's basketball tournaments are among the biggest money makers for the NCAA, but a case is being argued today in front of the Supreme Court, and it could restructure the finances behind those college athletic programs. The NCAA makes $1.1 billion in revenue annually, and much of that comes from television profits. Now, we should note that CBS contributes to the organization's revenue with a multi-billion-dollar deal for March Madness. Now, players are now demanding a slice of the pie. And many athletes, you might have seen, are wearing these shirts with the hashtag not NCAA property. And they want to be compensated directly for the work that they put in for their schools. And today, the Supreme Court's 9 justices are hearing oral arguments in an antitrust case that challenges how the NCAA compensates athletes. A ruling in the athletes' favor could alter the organization's entire revenue structure and sports, really, as we know them. Here to discuss that case and the growing movement around player compensation is Matthew Mitten. He's a professor of law and the executive director of the National Sports Law Institute at Marquette University. He joins me now from Chicago. Matthew, thank you for joining us.
Yeah, my pleasure.
Welcome to the case, NCAA versus Alston. Now, you could have, this case could have major implications. So what are the arguments that are being brought forth by the players?
Well, the players' main argument is that the NCAA has what's known as monopsony power. If you want to play big-time college sports, it's got to be at an NCAA member school. And all of the schools have joined together to limit the economic compensation they can receive for their playing services. So they said there was an extensive trial out in Oakland, and the trial judge found that NCAA limits on the educational benefits that its schools can provide to student athletes violates federal antitrust law. So that's the one side of the argument.
And so how is the NCAA trying to argue against the athletes?
Yeah, the NCAA's basic approach is that, going all the way back for, more than 100 years, its member schools have said college athletes must be amateurs, which means no pay for play in order to distinguish college from professional sports. Current NCAA rules would allow member schools to provide athletic scholarships up to the full cost of attendance plus actual necessary and reasonable education expenses. And the NCAA's basic view is if the district court's ruling, which was affirmed by the Ninth Circuit Federal Court of Appeals, is affirmed, it's going to permit, or there can't be any national limits at the NCAA level on the amount of educational benefits that member schools can provide to student athletes. And the NCAA's argument is that if student athletes get, cash benefits, and other unlimited, in-kind benefits like computers, musical instruments, postgraduate scholarships that are not limited, that effectively becomes a pay-for-play system.
Well, how does this case differ from name, age, likeness arguments that we've seen in recent years around college athletes? And how are states taking the lead on making laws to compensate them?
Yeah, with the Alston case, the key issue here is what limits at the national level through NCAA amateur rules can be placed on what schools, the NCAA's member colleges and universities can provide to student athletes. The name, image, and likeness issues, very different situation. There, the question is, and NCAA rules have traditionally prohibited this, is, can student athletes now enter into endorsement deals with third parties, those who sell products or services, those who might want to put some advertising on student athletes' social media like Twitter, Instagram, Facebook. That deals with what economic benefits, contracts, arrangements can NCAA student athletes enter into with third parties. And the NCAA has said now they think student athletes should be able to, exercise their name, image, and likeness rights, which are based upon state law, similar to other student athletes, but there needs to be some guardrails to make sure this isn't disguised pay for play.
I imagine a slippery slope argument's also in play here. Now, based on the Supreme Court's current makeup, what do you expect from the case? And what could be the long-term implications of a ruling in the athlete's favor?
Well, on the one hand, you know, the problem in this case, well, if we look at what's the issue, should we let the NCAA schools have the ample latitude that the last time the Supreme Court looked at how does antitrust law apply to college sports? That was 37 years ago in the Board of Regents case, and it dealt with a completely different issue, is whether the NCAA could exclusively sell the rights to televise its member schools' football games. And there the court said, well, no, they can't, but the NCAA cannot do that. But the NCAA should be given ample latitude to maintain the difference between college and professional sports. And the question that the courts, you know, the justices are going to have to resolve today from today's case is, well, how comfortable are we? I mean, are federal judges applying antitrust law on a case-by-case basis be able to draw a principled line, or is it going to be ever shifting? The NCAA, of course, is concerned that every single one of its student-athlete eligibility rules, particularly those maintaining the amateur nature of college sports, could be potentially struck down by a court using antitrust law. So if the student-athletes win, it definitely has it likely will change the face of college sports.
Professor Matthew Mitten, thank you for sharing your expertise.
My pleasure.